everybody, welcome to Learn with Steph. This is one of the videos as part of our Lessons in Law series. The focus is on OCR A Level Law, but it will be useful to anybody studying law. If you like the videos, please do subscribe and press the like button at the bottom. This is our third lesson on judicial precedent. In our previous two lessons, we looked at what judicial precedent is and all the key terms that you need to know for your exam. The operation of judicial precedent in regards to overruling, reversing, distinguishing and following. In this third lesson, we're going to look at how judicial precedent operates, focusing on the Supreme Court and the Court of Appeal. We're going to look at the rules that govern judicial precedent in those courts. Remember that this topic will be examined for OCR A Level in Paper 2, Section A. So first of all, what is the operation of judicial precedent? We're talking about here how judicial precedent works within the UK court structure. Obviously, the first thing you need to know are the courts in the right order. You should already know this. Can you name all the courts and can you put them in order? Which one is at the bottom? Which one is at the top? Think about which ones are civil and which ones are criminal, and try to keep the civil ones at one side. What are those three courts in the middle? Hopefully, you know that the Supreme Court is our highest court and the Magistrates' Court is our lowest court. Then you've got the Crown Court, which is a first instance criminal court, and the County Court, which is a first instance civil court. Above that is the High Court, which becomes the Divisional Court when it is an appeal court. And within the High Court or Divisional Court, you have three divisions. The Chancery Division, that looks at money matters and deals with bankruptcy and that sort of thing. The Queen's Bench Division and the Family Division. Above the Divisional Court, you have the Court of Appeal, which is divided into a civil division and a criminal division. And then above the Court of Appeal, of course, you have the Supreme Court. There are two other courts that I've not included in my diagram, and these courts also do create judicial precedent for the UK. They are the European Court of Justice, which rules on EU laws, and so it sets precedents relating to anything to do with the EU, such as working rights and the environment. Clearly, that court will be very much less important as we move out of the EU, but any judgments that are made after our departure from the EU may well be persuasive on the UK courts. The European Court of Human Rights will continue to set precedent for the UK courts, and of course that deals with cases such as the right to liberty, the right to a fair trial. Both these courts create precedent on the UK courts. Let's turn now to the Supreme Court, our most senior court in the UK. And of course, the Supreme Court used to be called the House of Lords. And if you're looking at any old cases, they might well say House of Lords. And that will mean the most important case, the most important court, the top court in the land. So how does judicial precedent work in the Supreme Court? Well, the Supreme Court is bound by both European courts. So it has to follow the decisions made in the European Court of Justice and the European Court of Human Rights. The Supreme Court also creates precedent for all courts below it. So the Court of Appeal has to follow decisions made by the Supreme Court. And the Supreme Court is usually bound to follow its own decisions. But it's this aspect I want to go into a little bit more detail. The big question here is how far is the Supreme Court bound to follow its own past decisions? And there's been quite a history to answer this question. Basically, right up until 1966, it's an easy date to remember because that was the last time that England won the World Cup. So before 1966, the Supreme Court, or rather the House of Lords as it was known, had to follow its own past decisions. And a case to illustrate this is London Street Tramways. In that case, the House of Lords stated that they are now bound to follow their own decisions because they believed certainty was far more important than flexibility. However, in 1966, the then Lord Chancellor issued a practice statement, and he said the House of Lords is normally bound by its own previous decisions, but may depart when it appears right to do so. So the House of Lords is usually bound to follow its past decisions, but if it believes it's right to depart from them, it may do. And it's had this power since 1966. And it's important to have some examples of the practice statement in operation. So Harrington, the case involving child trespassers onto the railway that you no doubt studied when you looked at occupiers' liability. Harrington was the first time the practice statement was used in civil cases. In fact, it was the first time that any case used it. A criminal example of it being used would be RVG, which overruled Caldwell objective recklessness. You might remember the practice statement said when it appears right to do so. And the House of Lords has been quite reluctant to depart, quite often preferring certainty over flexibility. And an example to show this reluctance would be Jones v. Secretary of State for Social Services, where 4 out of the 7 judges in the House of Lords believed the President was wrong, but only 3 of them believed that they should depart from it. So the President remained. Try writing a 10-mark question. Explain how far the Supreme Court is bound to follow its own precedent. As you can see, I've divided your answer into 4 clear paragraphs. Try doing this answer to time. Let's move to the Court of Appeal. Now, the Court of Appeal is the court just below the Supreme Court. So it's a higher court, so it does make precedent, and it has to follow the Supreme Court's decisions because it's below the Supreme Court. However, the Court of Appeal binds all the courts below it. So the High Court has to follow the decisions of the Court of Appeal, as do the Crown Court and the County Court, because they're below the Court of Appeal. However, the Supreme Court doesn't have to follow the Court of Appeal decisions because it's above the Court of Appeal. The Court of Appeal is bound to follow the decisions made in the Supreme Court or past decisions made in the House of Lords and in both the European courts. Again, the big question is how far is the Court of Appeal bound to follow its own past decisions? The rules here are slightly different in the criminal division than those in the civil division. The criminal division has much more flexibility. Can you think of why this might be? Why might the criminal division of the Court of Appeal be able to depart more easily from their past decisions than the civil division? Let's look at the operation in the civil division first. The basic rule is the Court of Appeal is generally bound by its own decisions unless they fall within the exceptions laid down in the famous case Young v. Bristol Aeroplane Company, 1944. These exceptions are if a decision is inconsistent. So if there are two decisions in the Court of Appeal on the same topic, but they're inconsistent, in which case the Court of Appeal can choose which decision to follow. Then another exception would be if a Court of Appeal decision is inconsistent with a House of Lords or Supreme Court decision. In this case, the Court of Appeal must follow the House of Lords or Supreme Court precedent. And finally, another exception to the rule is if the decision has been made per incurium, which means in error, so or through carelessness. In other words, if a decision has been made but it goes against what's been said in the statute. So only if those three exceptions are present in a case can the Court of Appeal Civil Division depart from its own decisions. And you do need to learn the Young v. Bristol Aeroplane Company 1944 exceptions. As I said, the criminal division has much more flexibility than the civil division. After all, someone's liberty and reputation are at risk, aren't they? Again, the Court of Appeal is generally bound by its own decisions, but it can depart if the Young exceptions apply. But they can also overrule past decisions if they believe a decision has been misapplied or misunderstood, or of course if it conflicts with the Human Rights Act 98. So you should now know all topics in relation to judicial precedent that you could be asked a 10-mark question on for OCR A Level Law. Go back over your notes, make sure you know everything thoroughly, make sure you understand all the different rules, and try to produce a revision aid for yourself, because that will help you when we move to our fourth lesson, in which we're going to evaluate judicial precedent. That brings us to the end of this lesson in law. I hope you enjoyed it. If you did, please like it and subscribe to find more videos. Bye.